Next on the calendar is number 99, People versus Elliot Parrilla.
May it please the Court, Robert Dean for Mr. Parrilla. I'd like 2 minutes for rebuttal.
2, sir?
2 minutes.
You have 2 minutes.
The issue before the Court is purely one of statutory construction. We're not asking the Court to balance justice against the wording of a statute. We're asking the Court to interpret the statute correctly. If it does so, justice will be happening. Under Penal Law 15 and Section 15 and 15.10, regardless of whether a penal law crime is one of strict liability, the minimal requirement for criminal liability is a voluntary act. And under this Court's case law, that minimal requirement includes, even in the case of a per se weapon, that the possession be knowing and voluntary. And under that case law, with respect to per se weapons, there's the minimal requirement.
With respect to this instrument, it's a
folding knife.
It's a knife that is considered a gravity knife, right?
Well, no, I think there's a question there. There's a jury question there.
You think it's a jury question whether it's a gravity knife?
No, there's a jury question of whether the defendant is guilty of possessing the gravity knife, because what we have here is a folding knife which is meant to be opened in the normal way, and which the ordinary consumer would only know to open in the ordinary way. And you've got
a jackknife. Isn't that what they're called, the jackknife?
No, I think
you've never heard that.
I haven't heard that term, but this is opened in the normal way. Only a specially trained New York City police officer would be able to open it by the flick of the wrist, and they'd have to know that certain way to do it. You'd have to know that certain way to do it. And my client testified that he bought the knife legally, which he did, and he used it as a laborer, just like tens of thousands of people in New York State. And he did not know.
Yeah, well, I'm just unclear. You're saying that's a jury question, but there was a jury trial here. So are
Right.
you saying that the court didn't instruct the jury to make the determination?
The court instructed the jury that what the defendant testified to, which was that he didn't know the knife opened in that way, was completely irrelevant. And that the only question was, did he have the knife? And that's what we're saying is wrong. And
did he know he had a knife, as well as have the knife, or just the possession?
Did he know that he had
A knife, period, as opposed to
knife.
this type of knife.
as opposed to knowing the essential characteristic of this object?
You wanted to charge unknowingly possessed, and you didn't get it, right?
Right. And in fact, yes, exactly. That he had to know the essential characteristics of this knife, that it could be
He already
flicked
had to
out.
know it's a gravity knife, as opposed to he had to know he's got a knife.
He didn't have to know specifically it was a gravity knife. He had to know that it could be flicked out, that had that essential characteristic. If you look at all the other...
If this were a switchblade, would you say that he would be entitled to the same charge?
I think he'd be entitled to the charge. His road would be much tougher, unless, of course, as in People versus Woods, he had a cigarette lighter which had a secret button on it somewhere, and the knife flicked out.
How would we exempt the gravity knife or any of the other weapons in 26501 in light of our holding in Saunders?
Okay, so Saunders involved a firearm.
Right.
And so what I'm saying here is if you look at 26501, Subdivision 1, every object in there, including true gravity knives, has an obvious outside appearance of being a weapon, a foul and illegitimate weapon.
Does a gun have an obvious outside appearance of being operable?
It doesn't matter whether it's operable or not. A gun is a weapon. So if you have a gun, whether it's operable or not, you know you have a weapon. If you have a folding knife, you don't know that you have a weapon, because a folding knife or a box cutter is a completely legitimate instrument. As long as there are boxes, they're going to have to be box cutters.
Does it make a difference that your client's looking at a felony as opposed to a misdemeanor?
No. it doesn't matter because it's a misdemeanor if you possess a gravity knife.
So in a misdemeanor case, you have to show the knowledge element that you're talking about.
Right.
So the
And
New
what
York's-
elevates it to a felony is just a prior conviction of any crime any time in the past.
Right. So it would have
really
to
it doesn't
apply to
matter.
every case,
Doesn't matter.
misdemeanor or not.
Right.
So the New York State, for a misdemeanor, would have to have a knowledge element in it.
The knowledge element is a minimal knowledge element of a voluntary act that you know you have something with the essential characteristic of the object. And if you look at every other object in there, whether it's a gun or a bludgeon, a metal knuckle knife, by the way, most
so
of
if you
these,
look at the statute,
Yes.
they're all the same, right? And so if we say that for these other items, it's okay for the legislature to say that it's strict liability, as we call it, you don't need to know its characteristics. What is it that takes this type of knife out of that? I understand you're saying because you can't discern its nature as a weapon, but is it a constitutional argument that you're making?
no, we're not making, we've been making a purely statutory argument here. That's,
So how can you make the distinction based on the statute
this is
itself?
what I'm trying to say. If you look at every other object in there, including true gravity knives, the outward appearance of the object says that this is a weapon that is
I know,
not.
but the legislature put it in the same statute with all of those other things.
Right. So what makes the gravity knife here different is that when you look at it, this looks like an ordinary folding knife that is possessed by laborers that they would not know opened like a gravity knife. It's a folding knife.
So
And
we would
it's
find that in this particular case, because of this particular knife, it takes it out of that statute. So we would substitute our judgment for what this looks like to the average person.
What it looks like to the average person, unless they're a specially trained police officer, is a common ordinary folding knife that is sold legally in stores across the country. It's sold on the Internet, including Amazon.com. It was sold legally in New York before 2010. And looking at every other object that is in this statute, you would see the essential characteristic of this object. If it's a metal knuckles, you know you got metal knuckles. Most of these objects, they have no statutory definition in the statute. It's not defined. Metal knuckle knife, billy, blackjack, bludgeon, plastic knuckles, metal knuckles, sandbag, sand club, slingshot, they're not defined in the statute because you know when you have them, you have an illegitimate object.
You know, just to go off to a different direction for a second, are you familiar with the Eastern District case, Irizarry?
Yes, sure.
With this you are. Is this the same knife? It was.
Yeah, essentially.
Is it?
Yeah.
Yeah. And in Irizarry, they said that this knife couldn't be opened by centrifugal force. Right?
No, I believe that it could be, but most people would not be able to do it or even think to know that it opened that way. And this is a very specific case here. We're talking about.
The reason I ask is,
Yeah.
let me just tell you the reason I'm asking. The reason I ask is the defendant still incarcerated?
Yes, yes.
All right. Has there been a writ, habeas corpus writ brought under?
You mean a
this
federal
case
writ or federal writ?
Yeah, yeah.
Well, the conviction is not final, so it couldn't be a
it's not
federal
final.
writ.
Okay, all right.
I think
Counsel?
my time is up.
Counsel?
May it please the Court, Andrew Seawald for the People. Your Honors, the appellant in this case is asking the Court to effectively decriminalize the possession of gravity knives. And perhaps there are some good public policy arguments for doing that, but if it's going to be done, that should be done by the legislature. A knife.
Why is that? Because you won't be able to establish this particular element? Is that why?
Yes, that's why. It would make it almost impossible to prove that a defendant possessed a gravity knife if the prosecution was required to prove that he knew that it had the characteristics that made it a gravity knife. That would essentially require him to be caught in the act of flicking it open, or making some sort of admission. I mean, it's theoretically possible to think of a way it could be proven, but it would.
But isn't the flip side the concern? In other words, that you just possess a knife and a police officer comes by and has been argued, he flips it and you go, holy cow, I didn't even know you could do that.
Well,
Maybe you can't.
The question is whether it was within the legislature's prerogative to designate gravity knives based on the inherent dangerousness of the fact that they can be flipped open very easily and lock into place, whether it was within the legislature's prerogative to designate those a per se weapon. And this court has said...
But what's the jury supposed to decide?
The jury is supposed to decide whether the defendant whether he possessed the knife, and that means aware possession, that he was... That's the voluntary act that was necessary to be proven in this case, aware possession. Did he know that he was possessing the knife, and was it a gravity knife? That's what the jury...
Are they supposed to find that too? That it was a gravity knife?
Yes. In fact, yes, that it fit
Why did the court
definition.
say the proper instruction of the jury is that the knowledge element would be satisfied by proof establishing the defendant's knowledge that he possessed a knife in general, and did not require proof the defendant's knowledge that the knife met the statutory definition of gravity knife?
That's right. And under Saunders...
You have to prove gravity knife.
The prosecution doesn't have to prove that the defendant knew that the knife fit the definition of a gravity knife.
Right.
But under Saunders, under Dryden, Brannon, this court has said that the weapons listed under 265.01, subsection 1, are per se weapons. And the language of the statute itself requires only that the defendant possess one of those weapons for him to be guilty of that crime.
Right, but does the jury, I think to Judge Pickett's question, does the jury have to find, separate from the knowledge requirement, that this, in fact, was a gravity knife?
Yes. Yes, that it
So then they have to find that it was a gravity knife and that he knew he possessed a knife, but they don't have to find that he knowingly possessed a knife.
That's right. Aware possession is the
And that's how you read Saunders.
Yes, Your Honor.
Could the legislature decide to put within that statute a small paring knife, just a sharp, very sharp knife, but one that's small enough that it could, fit inside a pocket or something and be pulled out and used, in the same way that you could use a gravity knife? Could the legislature say that a common kitchen paring knife is a per se weapon?
Well, probably yes, if the legislature determined that a certain type of knife posed some particular serious threat to public safety, as the legislature determined in this case with gravity knives when they arose as an alternative to switchblades, which had already been designated per se weapons. So the question is if there's some unfairness to the consequences of the legislature having designated a certain object a per se weapon, the question is what is the remedy for that type of unfairness?
The argument here is that the other weapons that are in this category are ones that if you've got it on you, you know that it's a weapon of a sort. Maybe you don't even know what it's called, but you know that this is a weapon. That's the utility of it, and you could appreciate that it might not be legal to carry it, right? He's not going that far, but I'm just going to add that. But he says with this kind of knife, the one involved in this case, defendant cannot do that, or at least claims he was not able to do that. He didn't appreciate that.
Well, on that top of it, the marketing of the knife itself is the Husky knife we're talking about, right? They were sold at Home Depot. There were tens of thousands of them sold, millions, I guess, in New York State alone. So from an equitable point of view, it's a little different situation than somebody with a star on them, say, or a chunk of sticks, those kind of weapons.
Well, first of all, there's no evidence really about how many of these knives were sold in New York.
But I've read a lot of these cases. There is those other cases. There's an awful lot of evidence on this issue.
Right, and I know...
Isn't that the point of the Manhattan DA's agreement with Home Depot over this, because they were selling these knives?
Well, one of the points was that Home Depot is not the legislature. Amazon is not the legislature. They can't determine which sections of a particular penal law statute are enforceable.
So it makes it ironic, because you can buy these knives in Buffalo, New York, and it's not a crime, but you can't buy them in New York City.
Well, Your Honor, the statute applies throughout New York. Now, there is an exemption built into the penal law for hunting and fishing and trapping purposes. So the legislature...
But let me ask you, it seems ironic, I know it's a statutory thing, but we're saying if you knowingly possess a knife and the knife ends up fitting this definition, you're guilty of a crime. If you possess this knife without knowing that you possess a knife, just a generic knife, you're acquitted. Doesn't that seem odd?
Well, there would really be no way to possess this knife, to be aware that you're possessing this knife without being aware that you're possessing a knife.
Sure, you're sitting in your car and all of, and there's this presumption, and all of a sudden they go through the glove compartment and they say, you got a knife. So I didn't know that knife was in there.
Well, then
that's one thing, right? But the other one is, yeah, it's my knife. Well, guess what? It's a gravity knife. Now, you're guilty of a crime, even though you knew you had a knife. You just didn't know you had a gravity knife, but somehow that doesn't make any difference. You see how odd that seems?
Well, it doesn't seem odd if you think that the legislature determined that those knives that can be flicked open are inherently dangerous. And there are good reasons for the legislature to have determined that. And in New York City, there have been a rash of stabbings recently, I'm sure Your Honors are aware of, and it's certainly rational for the legislature to have determined and to continue to determine that there's something more dangerous about a knife that can be flicked open.
Do we know whether those slashings that are occurring in New York City have been done by these kinds of knives? It could be just regular knives that somebody's pulling out.
Of course, Your Honor. That's why it's for the legislature to determine what the appropriate course of action should be, if any, with respect to gravity knives, whether they...
In terms of mens rea, you say, I'm in the flooring business. I cut tile all the time. So do I have a knife? Absolutely. All of a sudden, some officer, when I'm coming home, stops me in the subway and says, that's a gravity knife. That's news to me, because I've been using it for the last 7 years cutting tile. The fact that he knew he had a knife, no big deal. The fact that he knew he had a knife but didn't know that it was a gravity knife is of no consequence. It's a strict liability statute on that, right?
Well, that's right, Your Honor.
So he's going down.
That's right. He's aware that he possessed the knife, and the knife that he possessed was a gravity knife. And the legislature has determined that these types of knives, because of the way they function, are inherently dangerous and
it's okay to have them for fishing, hunting, and trapping, but not for work.
Well, that's the judgment of the legislature, and it was based on, in part, on the legislature's experience that, or finding that when there was an exemption for use in business for switchblades, that vitiated the effectiveness of the statute. And so, if the legislature wants to take up a similar exemption, revive that exemption for gravity knives, the legislature could do that. But for the court to carve out a separate rule for one particular weapon within that statute just wouldn't make any sense.
What does the defendant have to know or be aware of with respect to a shuriken?
I'm sorry, Your Honor?
The shuriken. It's right before Kung Fu Star. What do you have to know? What does your level of awareness have to be? What would the jury instruction look like for the shuriken?
I'm not familiar with that exact object, but you have to be aware that you
Join the
possess.
club on that one.
That you have to possess the object, I would say.
Possess it, so the instruction would just be the object?
That, and you.
How would you reference it?
Well, you have to have some awareness of the, that you were, yes, that you were possessing the object. I'm not sure.
Doesn't it then go to that characteristic that makes whatever this shirkin is uniquely a shirkin, as opposed to anything else?
I suppose if there were something about the shirkin that made its essential shirkinness incredibly well disguised,
Okay.
that perhaps could be a significant issue in determining whether the defendant was aware that he was possessing a shirkin. But in this case, I don't think there's any argument that the defendant didn't know that he was possessing a knife. And so he is responsible for the characteristics of that knife that made it a gravity knife.
Thank you, sir.
Thank you.
Counsel?
I'd like to make
Counsel, are the kinds of cases where the defendants are just mistaken consumers, to Judge Piggott's point, are those kinds of cases, or even your client who used his knife as for work purposes, are those cases ripe for motions to dismiss in the interest of justice?
Yes.
Did you pursue that here?
I don't believe that counsel below did. I'd like to make some very important points
People
here.
agree this is prosecutorial discretion.
Yes. One very important point here. The people here seem to be conceding that you do have to prove that the defendant knew he had a knife. Well, actually, that's not their position. Their position, if you read their brief, is all he has to know is that he had the object. So when the people are saying, well, yeah, he had to know he had a knife, well, now they are conceding that the defendant has to have some knowledge of the essential characteristic of the object. And I think this is very important. They have changed their argument in order to make it seem more reasonable to the court.
So you're saying now they're saying you have to know some characteristics,
Yes,
but you don't have to
exactly.
know all these characteristics.
Yes, exactly. Exactly, that is my point.
And that's
If you
not
read
what
their
was
brief,
argued before.
and now, so they've partially conceded our argument even in the face of questioning from this court.
What was the jury instruction?
The jury instruction is it didn't matter whether the defendant knew the essential characteristic of the object. If he knew he had the object,
Is
and he's
that
guilty.
the word that was used?
I'm not,
Object?
the court could have said if he knew he had a knife. But my point is that's not enough. Also, if you possess...
How would the rule you're advocating here apply to shirkin?
Shirkin is actually a kung fu star. And my point is,
Thank you for...
if you have a kung fu star, you know you have a kung fu star. And if you possess this knife in Buffalo, you're guilty. It's just that the cops in Buffalo haven't realized it yet. But they'll realize it if you rule against me. Then they'll know.
You're gonna send it out.
Because under the people's position, it's illegal all throughout New York State.
Right.
All throughout New York State. And the final point is, you have to exercise some idea of context. What's a bludgeon? What's a bludgeon? Have you thought about that? Well, if you go to a Yankee Stadium game, okay, on Souvenir Bat Day, and they give you one of these souvenir bats, well, you could hit somebody over the head with that and do some damage. Is it a bludgeon? No. But if I take that object home and I take a strip of leather and I wrap it around the handle so that it's got a loop on it so I can stick my wrist through it and then hold the handle, that's a bludgeon. I know I've got it. I know I've got a weapon. That thing could only be a weapon.
But he says that it then isn't going to end up being a strict liability.
It is strict liability for the most part, but you have to know the essential
That's
characteristics
his point.
of the object.
That's his
you
point
possess.
about trying to establish that, right?
It's a minimal
People will say, I didn't know.
scienter requirement. And the defendant testified, I didn't know, and the judge told the jury it doesn't matter.
So then it's a jury question is what you
It's a jury question.
Thank you, counsel.
Thank you.